slightly after 1 p.m. on Tuesday, the 5th of August, 2014, in the City Center Conference Room. As one who has been absent for an extended period, may I say how good it is to join you once again. And welcome to all who have come to be with us. I invite Ms. Jorgensen to lead on the roll call.
Louise Jorgensen.
Brian Jones. Matt Taylor.
Hal Miller.
Gary Garrett.
Stephen Hales.
Kay Van Dave Sewell. Gary Winterton.
Kim Santiago.
John Curtis. Wayne Parker.
Thank you. Daniel Quick, who is a council policy intern, will offer the opening prayer, and we've also invited him to introduce himself and his position in brief fashion.
Our dear Heavenly Father, we are grateful for this day, and we are grateful for all the many blessings that Thou hast bestowed upon us, Father. We are grateful for the opportunity we have to live in this marvelous city, in this great state, in this great country. Father, we ask Thee at this time to please bless us, that we can be guided in our conversations to work out the best ends for the city and for our community, that we can help those people live happy and comfortable lives. Father, we love Thee so much, and we ask for these things in the name of Jesus Christ. Amen.
Amen.
I've been introduced a couple times already, but my name is Dan Quick. I am currently interning with the council office while I'm attending school at BYU, doing a JD MPA, so law school and Master's of Public Administration. And I've been working here for about 3 months now, and I'll be here until next April. So if you see me in the hallway, Dan Quick is my name, so be sure to say hi. Do you have any questions for me, or?
Where are you from?
I'm from Lexington, Kentucky, so transplanted to the West. Correct.
That joint JD MPA suggests overachievement.
Perhaps, or lack of direction.
Did they give you a certain specific assignment for a specialty that they want you to be working on, or is it just whatever you get, you get?
So I've been working on the code audit that we discussed last work session. So I've gotten to read through a lot of code and watch all of your meetings and see what we can do better. So it's been great to work with you guys in the background, but look forward to working with you in the future. So thank you.
Thanks, Dan. I will take the prerogative to move beyond items 3 and 4, to which we will return, to directly to items 5 and 6. Item 5 be presented by Mr. Garrett regarding the Council Governance Committee's recommendation regarding the Gustafson complaint, and then Mr. Sewell, the Interlocal Ethics Commission recommendation. My reason for doing so is because we have with us today our distinguished former mayor and municipal council member George Stewart, who has come explicitly to talk to these items. Is that accurate, Mayor? Thank you. Yes, indeed. We look forward to it. So, Mr. Jarrett.
Thank you, Hal. So you may remember the letter that was submitted to council by Andrew Gustafson earlier this year, and Matt has the original copy of that. Maybe you can just give us a quick summary of that, Matt, and I'll move to.
Unfortunately, I don't have the original copy right in front of me right now, but in summary,
Yes.
It's in our notes packet. It's a very page 55 of your decision.
in summary, there were two main issues. One was, well, in summary, the related issue what we're discussing is there a legal conflict of interest between Mr. Jones being an employee of the legal office and his ability to, without bias, represent the interests of the council. That was expressed concern in the context of a bus rapid transit issue and a referendum that the citizens had initiated. And Mr. Jefferson had made some assumptions which were probably not accurate, though, that that he believed, though, indicated proof that there was this legal conflict and that the council may not be getting fair representation. I think there's two issues. Oh, and then he also went into about why what he perceived as a determination on this BRT issue was not a correct determination. Ultimately, actually, I think our legal department agrees with his rationale on the BRT issue. But that's really ancillary to the issue at hand before us today, which again is there a legal conflict of interest by having Mr. Jones represent us from the city attorney's office.
Great, thank you, Matt. So if you had an opportunity to read the opinion piece that Robert West put together, and then he attached a lot of the code as well from ethics.
It's not in the package, it was the email that Matt sent.
Okay, it's not.
It was attached to the email that Matt sent.
Okay. Okay.
Yeah, and the purpose, it is a draft document, and at this point, Mr. West is requesting feedback before he finalizes that document. If there's any areas that you would wish either be examined further or evaluated with a different paradigm, and he's interested in that feedback before he finalizes it, which would make it a public record at that point.
Okay, that's right. Thanks for that clarification, Matt. So it is a first draft document, and he's at this point looking for feedback. So on our governance committee, Mr. Sewell and I have had a chance to discuss this and review Robert West's legal opinion. And again, I mentioned he includes references to city code, to the state ethics rules, and also Utah law he uses as references. But he basically, in his analysis, makes two particular points. One, that the council and the mayor are basically the same entity. They're considered, they're the same client, considered branches of the city. Specifically, the Provo City Code section does not distinguish between the council and mayor as separate clients, but instead identifies them as branches of the same client, which is the city. And he refers also to the ethics rules in stating that it's okay for the city attorney's office to represent both branches of government as long as there isn't a specific conflict of interest. And one of the conclusions that he draws is that the ethics rules for state lawyers do not preclude a city attorney's office from representing and advising both the council and the mayor simultaneously on a particular legal matter. And that leads to his other point that he says not only is it not precluded, but the ethics rules actually provides for such circumstances that the attorney represent both if it's part of their duties. He makes several references to the duties of the attorney's office, the city attorney's office, including directing and coordinating special counsel, preparing and approving all ordinances and resolutions, and approving legal form of contracts, and then considers this representation of both entities part of their duties as well. He states several examples, one including a case in San Francisco that it was a similar situation to ours, and feels that the law supports the position that he represents in his opinion piece there as well. So it's primarily those two things that he that he draws on, the fact that the city attorney's office can represent the council and the mayor because they are both from the same entity. And also it is part of their specific duties as long as there is not an adverse interest or conflict. So I don't know, Councilmember Swope, if you have anything to add to that based on our review and discussion.
I think the only thing I'd like to add is that we focused our discussion on this issue on the legal and sort of ethical side of it. Was there a legal problem? Was there a problem with bar rules and things like that? And concur with the opinion that there wasn't. We didn't really address the issue from a functional standpoint of are there advantages to having separate representation. I just wanted to mention that as government entities grow larger, that tends to become increasingly common to have separate representation for the executive and legislative branch. And there are reasons for that, but there are also, on the other side, there's cost efficiencies and advantages to using the same staff as well for smaller entities. So that's all I want to say is that we didn't address that side of it.
Can you give us any examples of adverse? You talked about where there could be adverse situations. And I'm trying to find out, clarify in my mind where they would be legally adverse that you mentioned.
As I
come to, and you see it.
Yeah, as I reviewed that, I myself I couldn't come up with a specific example, but I thought maybe Brian might be able to think of an example, Brian, where there would be a more clear conflict or adverse circumstance where...
Yeah, something like if there's an interpretation issue of a city ordinance, say there's an ordinance that describes a power that, say, the mayor has, and the mayor has a position that it means that he can do X, but the majority of the council feels that that's not right. He shouldn't be able to do X, and so he's trying to. So if it came down to a conflict over that issue of whether the correct legal interpretation of the statute is that the mayor or the council has a certain power, then I think that certainly constitutes what we referred to in some of these discussions as a functional conflict, where it would be very difficult for say an attorney to maybe not necessarily maybe to give advice on the issue, because I would hope that the advice would be the same regardless of who's asking, but certainly to advocate for one side or the other would be very difficult for the same person to advocate for both sides. But I think that's the kind of example that.
And I think it's important to note in that scenario that either the mayor or the council could retain that independent counsel, independent of the legal office.
And in fact, hopefully this doesn't go down too far into the weeds because of the specific issue, but going back to the BRT thing, that the example that was raised by Mr. Gustafson, I felt wasn't necessarily on point because I hadn't had any interaction with the administration on that issue. But you'll probably remember in the emails that I sent out that after I had my conversation with Dave Connect, that I told you that I went to Robert West and said, okay, I don't think that we haven't arrived at an issue regarding the referendum yet, but we could. Said it's possible that the mayor could take the position when it's time for the referendum to be certified, that he wants to certify it, the council would think that it shouldn't be certified. I said, so going forward, if that question ever comes up, I'm not going to answer any questions for the administration about that issue and refer them to you, and I would only answer questions for the council regarding that issue. And if it really turned into a fight, then Robert and I discussed that we both advised the mayor and you that it may be the kind of situation where you wanted to hire outside counsel.
Mr. Hayes.
I was just going to mention that I feel like everything resolved itself in the situation I'm about to mention. But I've admired the mayor's comments that we need to pay attention to these issues that might be different when the personalities change. So I think it's important that we have this structurally sound. Just as part of the example, when we were going through the BRT issue, we had a situation where the majority of the council had a different view than the mayor did. And so we were in a position where it didn't make sense that the city was the client. It was the council was one client, the mayor was a different client. And Mr. Gustafson brought his letter. Mr. Jones replied in a well-reasoned letter to all the members of the council, and I think he also sent it to Mr. West, and I don't recall, I think Matt Taylor, council members Matt Taylor, Mr. West. And he said, do you have any comments on this? And so I wrote an email, and I forwarded to the same group of people on how I saw that to be a problem, that the city is the client instead of having the council as a client specifically, and the mayor as another client specifically, especially in this case where there was a difference in opinion. And Mr. Jones responded again. It worked out, but the thing that surprised me was when I got an email from the mayor on that, because I had thought that I was just speaking to the council. And I think Mr. West had taken my email, which is proper again, but had forwarded it to the mayor, and then the mayor responded and just said there's some things that we should talk about. We eventually did talk about it and resolve it. But it was just surprising to me that as I discuss an issue that I saw pertain to the council, it would end up going to the administration and then come back to me saying, no, you didn't quite get it right. We've got to resolve these issues. So that to me is a demonstration of the challenge of having an attorney who represents everybody and not just the council, especially if there's a case where the council and the mayor disagree on an issue. So for that reason, I was a little concerned. One thing that gave me confidence is it mentions in the document that Mr. West prepared that it's an option for the council, or as you mentioned, Matt, for the mayor to get some counsel, specifically if they need to separate from the city.
Did reading this clarify the matter for you? Why the circumstances you describe as surprising would, in fact, in light of what's mentioned here, make sense?
It did clarify it for me. Again, the explanation of why it wasn't a problem, it didn't make sense to me as much as the idea that if we need separate counsel for ourselves, we have the ability to do that. As long as we have that ability and it's recognized, I think we overcome whatever issues there are.
What I found surprising in Mr. West's articulation was that, in fact, we are both clients of the same attorney, city attorney. And that means that that city attorney, unless there should be some client-attorney privilege invoked, would be in position to advise both clients.
That was surprising as well, and I think it's different probably than the way it's been considered in the city for many years.
I agree. That's why I was surprised by it. I appreciate very much what he's done. But did you understand this? I mean, it's written in a cryptic language.
Yes, it is. Chair, we are really in trouble.
No, I mean, it's like reading Shakespeare. You have to get into it a ways to adjust your reading style. It would have helped to have had a one-page digest, layman's terms or layperson's terms.
To your point, I ended up reading the first 30 pages, then the last 10. All those cases in between the San Francisco cases, I just kind of skimmed through because I didn't have time. But there was part in there that caught my eye where the attorney doesn't have to maintain that confidentiality with one entity if it's necessarily. So, and that personally for me, I mean, you're brand new council member and right in the middle of this type of situation, I didn't feel that I could go to our legal counsel. Because I felt like whatever I said to him would go straight to the administration, and we were on opposite ends of the spectrum on this issue. we didn't agree on this issue. And Mayor signed the referendum, the citizen referendum.
It's not true.
And, oh, I thought you did. Oh, you said you had a picture and you were gonna put it on Facebook and your own personal Facebook page, but not the other one. But that wasn't signing it?
With the benefit of hindsight, what might have happened at that point, in hindsight?
So, in hindsight, we were on different ends of the spectrum on the issue, right? And I didn't feel like I could use our legal counsel because I felt like whatever I discussed with him would go straight to the administration. I didn't necessarily want the administration to know what was going on because there was already pressure being put on the council to just go with what UTA had, coming from the administration, coming from lots of different entities. But I didn't feel like we needed that much more pressure. If they knew what I was thinking or where I felt like this we needed to go, then there would be all these meetings and pressures to get the council to decide, you know, to not do it. I wanted a fresh look. I wanted a fresh conversation. I wanted the council to be able to look at it as the council and not feel the pressures, outside pressures on it. So I didn't feel personally that I had legal counsel because for that reason, it would be a confidential.
So in hindsight, it might have been, that might have been sort of then an event that crossed the threshold where we said, let's consider retaining independent counsel.
It would have, but it would have been a timing issue as well because there was a lot of pressure coming from UTA. We have timing issues here. If we're going to do this, we've got to do it now. And so it wasn't feasible. It wasn't feasible to get a second opinion and then to bring someone else in and to get them up to speed on the issue so they would understand it well enough because it was very complicated. There were a lot of pieces to it. And so to bring in outside legal counsel to do the RFP, first of all, you know, to get someone and then to get them up to speed and then to have them help us, it just didn't seem practical or feasible. I didn't even think it was an option.
It may have seemed infeasible or impractical, but that doesn't necessarily mean that it would have been, had this been a serious consideration on our part.
Well, or if we had the political will to do it, and I didn't know that. I didn't know at the time if we had the political will to do that because there were so many pressures being put on council members.
Let me ask Mr. Jones if he recalls ever raising the prospect as we went along in any kind of open way about perhaps it's time to retain independent counsel.
Well, not that I can recall during the BRT issue specifically, other than I think it was probably mentioned in response to Mr. Gustafson's public comment and letter. I know that I'm fairly certain that was discussed at the retreat when we had the retreat conversation about what my role was and my background and where I worked and stuff. And I think that the perspective that's being shared is fine. It's very enlightening to me because it's a little bit interesting to me because I was sitting in the BRT discussion going, none of the stuff that we're discussing is legal. In my mind, it was entirely policy issues. So it wasn't even in my mind that conflict was an issue during BRT because I wasn't having any discussions with the administration about BRT, and I didn't feel like I was really advising either the administration or the council on legal issues because about the only issue I can even remember talking about was some questions about what UTA's statutory authority was and what the impact of the resolution was. But so that's enlightening to me as far as expanding my view of how the council members felt about that.
Don't you draft resolutions or does that sit staff? Do you typically draft them? Or staff does and then you look at them? Or? So that would have been one thing, I guess, when I was thinking, I mean, I wrote it and I brought it to the meeting and then we recessed so that you could look it over at that point. But those types of things would have been nice to make sure that it actually, you know, read right, had everything that it needed.
Yeah, and that's just, you know, I don't know if that's a failure on my part to communicate, but that's something that council staff stands by to assist any council member in their legislative priorities and to a certain degree, and certainly council priorities as it's been adopted.
Well, the issue specifically with the resolution was council chair, in leadership meeting, council chair Miller directed staff and I to prepare a resolution that met with what Ms. Santiago had proposed. But, I don't say this about Ms. Santiago because I recognize that this was a function of when the meetings were held, but the information was passed to me an hour before work session started, and so I don't know that that had anything to do with, in my mind, any functional concerns that we're talking here as much as just that we drafted it in an hour and reviewed it during the meeting.
Yeah, certainly the drafting process, we can pull Brian in, and he may do the lion's share at times of drafting, but often that's something that we'll.
And my point in bringing that up is not to point fingers or not to say, it just was what it was.
Yeah.
We didn't have legal counsel that I felt like, okay, this is the council only legal counsel, and it's not going anywhere. And so that was, for me, it was harder to trust in that, not you as a person, because, I think you're a great lawyer, I think you're right, you obviously know your work, and that was nothing personal, it was just, I didn't know where, I'd seen communications go this route, I'd seen it go from the council and straight to the administration, and because it's legal, I mean, that's, apparently when I was reading through this, that it can go that way, and so for me, I was not comfortable putting it out there early enough for it to make that route, and for, I don't know, I wanted the council to be able to have a conversation about it, unfettered by other opinions or pressures or whatever. I wanted us to be able, just as a council, to look at it, talk about it, and then, decide on it. So.
Well, let me make a comment about attorneys' rules of ethics in that sense. I think a lot of this has to do with how early in the year this occurred, and a lot of it had to do with getting to know each other, getting to know each other's roles and what they were. And so, merely because it's permissible for an attorney to share information among constituent parts of an organization doesn't necessarily mean that they will or that they do. And I don't think that any of the information, I don't recall ever passing any information about that issue to the administration. But, one of the things that I realized shortly after this, shortly after that event and this issue is that the communication was a little bit lacking. And I think that, which I think was largely something that I probably should have taken steps earlier to be more involved and try to meet with you. The meetings we've been having with Mr. Sewell on the weeks before council meetings, I think, have been productive when they've happened. But anyway, the point that I was trying to make is that at any point, the attorney's rules of ethics would have the situation happen in this way, which is that if a council member came to me and said, I want to discuss something with you, but I don't want anything that I say to go to the administration, I would be obligated under the rules of ethics to either agree to that or to tell you up front that I couldn't agree to that. If that makes sense. I'd be required to be open about the fact that in that particular matter, I couldn't do so. If that makes sense.
It does. And just to your point, I mean, there were other things that I did go to you about and had no problem asking you about other things, legal advice about other things. But when it came to something where we were not in agreement with administration on which way to proceed, that was where I personally felt like we really would benefit from having our own counsel, from having someone whose focus was just on the council and having that separation. And I look to the state government, I look to our federal government, those that have this type of government, they don't share legal counsel, they would never do it. I mean, I shouldn't say they would never, but the legislators that I know that I've talked to are like, we would never share legal counsel. And so those were some questions that were going through my mind at the time, and I could see why, because I was smack dab in the middle of something where I felt like, it would be nice if we didn't share at this moment, and we will probably agree on many, many things, and with that one, we just happened to have a different opinion, and I just, it was a moment where I really felt like it would be important, and I think down the road, we'd be foolish to say that we'll never, ever disagree. I mean, that's why it's the balance, that's the checks and balance, right? And so that's why I just feel it's important, and I feel like having someone, being able to hire someone when you need it, it's nice in theory, but in practice, it would have been really, really difficult, I think, just to get the political will to delay it enough to do that because of the time pressure, the pressure cooker we were under. But,
Mayor Curtis.
Thank you. Just a couple of quick points. I think I'm comparing this a lot to a private business, and I don't think it would be unusual that you would have two partners in a business with one attorney, and the partners disagreeing amongst themselves about how to move forward. As a matter of fact, I think that would be a pretty common thing. And so I'll point that out as part of an explanation for this relationship that might feel a little bit awkward. I'd also like to point out that the odds are just as high the council disagrees amongst themselves. And so you take the mayor out of the situation, it's very high likelihood that 3 or 4 of you would disagree with 3 or 4 of you. And that you can find yourself in that exact same situation, even with your own lawyer, just to the council. And I guess if you take this to the extreme, the council member could come in and argue for a lawyer per council member, if that makes sense, so that you would never have that situation. And I think part of the reason I'm sharing that is just the practicality of the situation. It says when we're on the same page almost all of the time, there is tremendous benefit to having a single office of legal advisor, just like a business doesn't hire a separate lawyer for every department within the business. The other thing I have to bring up is this concept of confidentiality, and to the extent that things were shared and reshared that shouldn't have been, I think all of us regret that and wouldn't want that. We want to have good confidentiality. At the same time, we live in an environment where, with very few exceptions, everything we do is public and can eventually be accessed. And so most everything I write, if not everything I write, I assume you all are going to see it. And it's probably good advice to say that goes the other direction. However, I do believe that it would be wise to filter in a conversation with Brian or Robert or even amongst our peers that says, look, this is just for you, your eyes. And to the extent that they can legally do that, or that I can legally do that, I think you would find a tremendous amount of respect simply for that acknowledgement that, hey, this is different. I want this to stay between us.
I could add just another paradigm shifter. I think under, especially reinforced by what Mr. West's statute is, and what clearly the city code and state code say, I think some of the focus is really focused on Mr. Jones being the council's attorney. And here's the paradigm shifter. Mr. West is the council's attorney, and Brian is here by assignment as Mr. West's not delegate, but proxy or delegate. And now recognizing, and so really Mr. West is the council's attorney, just like he's the mayor's attorney. And everyone in the legal office is a delegate or subordinate to Mr. West, and Mr. Jones is here by assignment. Having said that, I know that they recognize the inherent functional conflict that can arise from time to time. And so in their relationship in the city's attorney office came up with rules for how to manage that conflict when it does arise. And also, I think, importantly, always recognizing this option for the third party legal advice. I think at a minimum, my recommendation would be that we have a qualified list of attorneys that maybe specialize in certain areas of city law or related law that the council can call upon at a moment's notice should the need arise. To try and get one attorney that has broad municipal experience may be difficult. They'd have to be probably a former city attorney themselves. That certainly is a prospect in itself, though. So there are options for being more ready to call upon that third-party legal counsel if needed. And I'd certainly work with the council and this committee to prepare us should that need arise.
Comment too, if it's appropriate.
Please.
it's been mentioned that we didn't really have any legal issues that we were trying to resolve. My understanding was that we did have a legal issue, and it had to do with the referendum. The city attorneys were telling us that it was fine for a group of citizens to begin the preparation to put on the ballot this issue that affected bus rapid transit. And yet we had people who were outside the city, who were attorneys, telling us that was not legal, that the resolution couldn't be affected by having a referendum. It had to be something that actually made law. And so in that regard, we felt like we were getting a difference of opinion.
Well, Mr. Mills, and you know, maybe I misinterpreted one of Mr. Sewell's emails, but as I look back at the time, the reason why I maybe have a different opinion of that is because I don't recall ever being asked that question. The only person that I ever had that conversation with was Mr. Connect.
It came up in the council meeting.
Right, it came up in the council meeting after Mr. Gustafson had raised his, after he'd stood up and made his public comments.
So in fact, I
Because
think,
the referendum started the week before that meeting. So at the point that Mr. Gustafson stood up and made his comments, I had not had a discussion with anybody, administration or council, about the referendum issue, other than Mr. Sewell had sent me an email saying, can you point me to the statutes that talk about referendums and initiatives? And I sent him an email back saying, here's the references and kind of a summary about referendums and initiatives and how they work. So I didn't feel at the time, which is part of my perplexity about Mr. Gustafson's complaint, I didn't feel at the time that I had given anybody any counsel whatsoever about whether the referendum was appropriate or not, other than that Mr. Connect had called me and said, don't you think this case says that it's not appropriate? And my response to him was essentially, you're not my client. But that's a good question.
I think it's just the way that I'm remembering it, and I could be remembering it incorrectly, but we knew that it was happening. We were hoping that if it was not legal, somebody would come and say, you know what, these people are misguided. They can't do that.
right. Yeah, I think one of the challenges to that is the referendum happened after a council meeting. And the specific Gustafson letter came at the following council meeting. So there was about close to 2 weeks, probably more like a week and a half. And I think it's difficult to say we as the, I'm putting myself in your body, we as the council have an opinion. There was no opportunity for the council during that time period to express an opinion. Certainly certain individual council members may have had their opinion, but I don't know what the council opinion was on the referendum, because there had been no opinion expressed. And there may be feelings because I think the problem is, and any councilman will correct me if you think I'm asserting a wrong picture here. But I think the problem is because the BRT resolution at that time was not in support of the preferred alignment, or well, locally, you know, using their terminology, locally preferred alignment, and because that by inference should mean that the council is also against the referendum. And that's something that maybe could have been a safe assumption, but it still would have had to be an assumption on Mr. Jones or my part. And without actual formal guidance from the council, in some ways the referendum was a different debate topic.
Sure. Part of the concern I had was that, you know, I didn't know that it was going to be illegal to have a referendum on a resolution. I didn't have any idea about that until an attorney came to me and said, didn't you know that they can't do a referendum on an issue that is not going to be law? And I didn't know that. And I was just wondering, why didn't our attorneys tell us this at the very beginning?
And this again, maybe, well, anyway, I was about to go down a different track. Just to answer the question, the reason why I didn't come forward and say that is because I believe then, and I still believe now, and I suppose that, and Mr. Gustafson even is the only attorney that I know of that's ever been involved in this debate, and even he hasn't ever specifically said that he disagrees with me on this point, is that even though the resolution ultimately could not have been certified, there is no legal means of stopping it until it's presented to the county clerk to the city clerk for certification. So in my mind, the question of whether it was legal or not was a month down the road, because there's no way to, I think the statute is absolutely clear that there is no way to stop it until the signatures have been collected.
That was, I think, one of the things I wrote in my email. That may be completely true, but why not just tell these people the day that you present it, we're going to tell you it's illegal. And so why go through the effort?
And I think in the meeting, actually, you suggested that it was possible. And if I remember right in the council meeting, that the referendum was a possibility of an outcome there.
Well,
but I don't.
Again, it was a really complicated thing because at that point, again, you'll go back in the meeting. This was 4 days after my phone conversation with Dave Connect, which took place after I had already been told by council members in some email that they thought the issue was already resolved, and that in the next meeting, the whole thing was going to be made moot by a resolution that superseded the resolution that caused the referendum. So I hadn't actually done any analysis at that point because, one, it wasn't time for the referendum to be challenged, and two, the only information I'd received from any council member at all about their opinion of the referendum was the message that said, we're going to pass a resolution in the next meeting that supersedes the one being challenged. So, and I had never been asked by any council members whether there was a way to challenge it or not. And to Matt's point, I can see the frustration from some that those who didn't want the referendum to happen probably assumed or felt, and maybe appropriately, that I should have assumed they wanted us to try to stop it. Frankly, that never even occurred to me. Frankly, I think it's kind of a First Amendment freedom of speech issue to try to stop people from gathering signatures on a petition that says what they believe about an issue, whether it's ever going on a ballot or not. So it was not clear in my mind that the council as a body, in fact, it hadn't even been hinted at to me by anybody, the council wanted that question to be explored, whether you can stop it. So what I said in the meeting was not really intended to be a legal answer as far as whether you can stop it or not. It was intended to be an explanation based on Mr. Gustafson's public comments about my conversation with Dave Connect. And my conversation with Dave Connect was, it appears that this case is on point. It appears that there's a probability that based on this case, it could shoot it down. But here are some other cases that I'm aware of that might be contrary. I don't know how the Supreme Court would decide this. I think I said in my email that I sent to all of you that I personally agreed with the interpretation of the cases that said that it would get shot down, but I didn't think it was absolutely black and white. It would be if it went all the way up to the Supreme Court.
Mr. Norman, Mr. Garrett, this is, as we hear this discussion going back and forth, this is where I have a little bit of concern. It seems to me that we have some council members that would like to have the attorney come in and maybe give his opinion, and I see a bias coming in with a certain group, maybe 4 council members or 5 council members versus the opinion of 2 others. And if we're asking an attorney to come in and all of a sudden start giving legal opinions before they are actually asked for, that's when we delegate some of our responsibilities as council members to outside counsel. And that's a concern that I would have for this. But I understand the concerns, and so I think it puts a responsibility on us to go to the council and say, can you advise us on this? And then we get into the conflict that Kim's concerned about, where that goes to other places. And I can understand that. I think this is just a discussion that we're going to have down the road here, at this point, I guess, and weigh the cons. I can see advantages and disadvantages to both. And so,
before I summarize where I think we are at this point, Mayor Sturgeon, was this an item you had come to talk to? Please do.
Moving to front.
Yes, please.
Let me preface my remarks by saying I love John Curtis. He's a great mayor. I have to disagree with him on this issue. The very fact that Brian Jones is having to defend himself to council members is so unusual. I've never experienced it in 7 years. It just shows why you don't have the same council. There shouldn't even be a question that there would be a conflict of interest. That shouldn't even be. The last thing an attorney wants is to have a conflict. Any of you that have been in business know that. In fact, when we sold Corporate Alliance to my son-in-law, the Kerwin McConkie sent us a letter and said, we can't now represent you and Corporate Alliance anymore. There's another company called The Influence that's owns a part of it. They were so concerned about any kind of conflict. They had a signed letter because we wanted them to represent both of us. That's the last thing you want, conflict of interest. And Brian is uncomfortable. I've watched him. I've watched him going through this, what he went through. He shouldn't have to go through that. Robert West shouldn't have to be questioned whether he's prejudiced, and he is prejudiced to the mayor, as Gary Gregerson was to me. Absolutely. There are will employees, for heaven's sakes, ladies and gentlemen. And, I mean, you don't have to cast aspersions on anyone to know that when you're a will employee, you're going to. I wasn't surprised at Robert's decision. It could have been the other way. But I wasn't surprised because I know who he works for. I know what the position of. And it's interesting that it is not, I don't disagree with his opinion that it would be illegal to represent both. Absolutely, I don't disagree with that. Would it be, is it practical? It's the best thing. It's interesting you had to go to San Francisco to find an example of where it's okay. We have many stronger forms of government in Utah. We have a legislature, and none of them do it. So why are we so unique? Why is this such a good idea to do this to save a few dollars? If that's the purpose, that's the purpose I heard. Ladies and gentlemen, you say you will uphold the Constitution of the United States and the state of Utah. And the Constitution of this state is interpreted by the legislature through their acts that they do. They passed a law in Utah that allows cities to have a stronger form of government where you have a complete separation of power. Complete separation of power. I think that was the intent of the legislation. As I talked to our legislators, including the speaker, she said that was the intent of the legislation. In fact, it was voted on by the citizens of Provo. They wanted that form of government where you didn't intermingle in the weak form of government. The mayor really has no power. That's why I didn't run the job. I wouldn't have run for the job. The weak form of government because he's a member of council. So there's really no conflict because you have a single body that controls the city. The mayor really can vote in some cities. Sometimes he votes only in case of a tie. So I was so surprised when I found that the city would choose, or the city council would choose to have this council be the same as the city's council because it opens the possibility of nothing else, of a conflict. Opens the possibility. Why would you want that possibility? Why would you want to put your attorneys to that? A possibility of conflict. Council Kim Santiago, Councilperson Santiago, Kim, shouldn't even worry about when she talks to her legal counsel whether there might be a conflict. She shouldn't worry about whether it's legal or not legal, a legal or not legal opinion. That shouldn't even be her issue. She shouldn't have to worry when she talks to her executive director. And I've been surprised that Matt's supporting this consolidation of legal. I mean, when I was mayor and when I was on the council, the executive director relied heavily on the council, legal counsel of the council to help him and her in their job. So again, the founding fathers felt it was the right way to have separation of power. And of all jobs, other than chief administrative officer as the mayor, my legal counsel was my most important person. Gary Grace did a great job. When I was the council chair for two times and the council vice chair, we relied heavily on Neil. There were questions of separation of power. And there was a disagreement between Robert and Neil on that issue. And we finally resolved it, but it was a compromise because Robert felt one thing and Neil felt another, and we came up with a compromise that worked for both of us. But had we not had Neil to help us in that, Robert would have, got what he wanted, which was the administrative position, which he should be advocating the administrative position after all. Because you all know in legal matters, there's a lot of gray area. For saying that, and I'm not impugning Robert's motives at all in his opinion, but you can write an opinion legally. I've seen legal opinions that differ completely. So why would you want to rely on the legal opinion of another branch of government? I just don't understand why. Jim Collins said in Good to Great, who you have on the bus is probably the most important thing in any organization. And I really believe in separations of power, ladies and gentlemen. I've been on both sides. I love being the mayor and I love being on the council. But I strongly believe they should be separate but equal. And when you have the council attorney working for the city administration, it is not separate but equal. It can't be, because they are going to have a natural prejudice toward the people they report to and who make the decisions on their advancement. And I'm not impugning the motives. That's just the practicality of the issue. I wrote lots of notes. Well, and to the issue of going outside for counsel, that's so impractical. I mean, all of us, I think, realize if you have an issue tomorrow at a council meeting, you're not going to go find outside counsel that has the time and is knowledgeable enough on the issue to give you good counsel. You wouldn't find anybody, a good counsel, that would do that. I don't know why they would. So, again, just to say, this is a $170 million business. The mayor is equal in power to the city council. You got two branches of government. I don't understand why 7 people don't need separate council versus the 1. And that's why, when I took over, when I was elected mayor, the city council did not have an executive director, which we supported strongly having them have an executive director because they were ineffective without the executive. Can you imagine trying to operate the city without an executive director? I mean, that's absolutely essential. And then they got a legal counsel, and that was a very positive experience. Any questions at all? Obviously, I have a prejudice, but it's not a prejudice toward the council or a prejudice toward the administration. It's a prejudice toward the form of government that we voted for, citizens of Provo, to have separate but equal branches. And I think that's near impossible when you have of all the important positions, your council being the same person.
Mr. Van Buren. I'm sorry, Mr. Winterton.
Yes, thank you, Mayor. I appreciate that, your input there. Can you tell me, and these are rumors, these are feelings that I've heard from other council members, that when leadership changes, I don't like the opinion of what this attorney gave us, so we're letting this attorney go. We want somebody that will agree with us as the new leadership group. And so did you ever experience that as a mayor or the council where certain factions within, say, the council felt that they're represented leadership rather than the whole council because they were kind of at will with leadership?
Well, I think it's possible that members of the council, when I served on the council, could have felt that Neil was prejudiced toward leadership. I think that's possible. He didn't serve at the will of the leadership, he served at the will of the council, so that would be very smart, particularly since, I can't really comment because I wasn't here when he was replaced.
And I don't know, these are all things that, and I don't even know anything about.
But again, if you take the job as council director, council attorney, or any of the directors in the administration, you're at will. That's okay, and of all the jobs. I think the council has to be sure that who's their attorney and who's their executive director represents them. At least represents the majority, because the majority rules in any kind of the legislature. I'm sure the Democrats would not like to have Becky Lockhart as speaker. They probably don't even like who she's hired as the head counsel for the legislature. Maybe or maybe not, I don't know. But that's the way government works. You got 4 votes. You try to satisfy everyone, but that's pretty hard. You get it?
Do you think that the council could, in your opinion, get by with a part-time attorney, or would it need to be full-time for?
Of all the jobs that we needed because of land use issues, which you're gonna be fixing a lot of them, you need to hire a good land use attorney and one also that understands separation of power and understands government. That's why Neil was so valuable to us, because he worked in the community development department. I can't even imagine writing my own statutes. I never did as mayor, I never did as a council person, even as council chair. I shouldn't be put in that position, that you never have to do that. I think why would you cut on such an important position?
So he was full-time? Or was he?
I think need to be full-time. Let one of your interns go.
Plug your ears.
Who's more important?
Yeah, no, I think it's.
Give me a break.
critically important.
Who's
I
more
agree.
important? Your council attorney or an intern? And I don't mean to diminish, how the office determines to run itself, but that is determined by the council, not the executive director. 4 votes of the council determine how they're going to operate their council. And that's okay. And it could change when the votes change. But that's if you take an at-will job, that's part of what it is.
Thank you very much, Mayor Stewart. We appreciate your insights.
Okay.
Mr. Garrett, Mr. Kirk, Mayor Curtis.
By the way, too, about Mayor Stewart, he's been a good mentor to me.
We've never had a better mayor.
Well, no, that's not true. I appreciate his wisdom to you. Let me just clarify that the administration does not have a position on this. We are not advocating that you use our attorney. Several years ago, when Neil left, he resigned. Council went through the process of interviewing attorneys and was unsuccessful. Came to the administration and said, "Can you provide an attorney?" And we have done so and have felt like it's been a good relationship. So from that perspective, it probably feels like we're advocating it. I think Brian loves and enjoys serving with you, but all of you need to feel comfortable that he has a very secure job without the council responsibilities. So I hope you don't feel pressure from us in this decision, other than should you decide that you want to use Brian's services, we think it works well and we're happy to continue with the relationship.
Thank you, Mayor.
Let me just make one more comment. I think if you talked to Mayor Billings, it would have been much more comfortable for him not to have to deal with Neil. Because Neil was good. I appreciated having been on the other side, having been at Mayor Billings' place. And conflict or difference of opinion, this came from my council, I'm a branch president at the NGC. He said, and he's 4 bestsellers of Mayor Exchange, New York Times. He says conflict is okay, contention is optional. And so there's no reason that you can't have conflict of difference of opinion should exist between the 2 branches of government. We should have healthy tension between the 2 branches of government. But you should never be contentious. And that's a sad thing when it becomes contentious. And I think sharing your council could cause some contention. Thank you.
Thank you.
Mr. Miller, I need to add that it is not my position to support either direction, other than to share with you the benefits and trade-offs that come from either approach, and whatever the direction of the council is, has always been my view.
Thank you.
It's an outside person, it's not what you did, man.
Mr. Garrett, I wonder if you and Mr. Sewell would be kind enough to consider revisiting, in light of what Mr. West has provided us relatively recently. The issue has gone much farther than anticipated, but I think it has gone to the heart of a concern where it would have eventually led. So we thank those who participated in the conversation for carrying it to that subsequent point of concern. Is the code, the municipal code as it now exists, is it adequate? Should it be altered? Should it be altered first or as one alternative to create a kind of trigger rule for when independent counsel would be sought, given the precedent that Ms. Santiago and Mr. Hales and others have cited? The further question is, should it be altered in such a way as to provide for an independent counsel, as was once upon a time the case.
Okay, we'd be happy to do that.
Could you also give us some, I'd be interested in costs for an independent counsel versus, savings for an in-house and hiring an independent as needed, but I'm interested in some costs.
That's a kind of side analysis, if you don't mind.
Okay. And then part of our objective also is to get a response back to Mr. Gustafson. So please provide us with any input you have on the opinion that Mr. West has prepared. That would be part of a response that is delivered to Mr. Gustafson.
Although one response to Mr. Gustafson might be, we continue to study the matter. We have not yet come to a final decision.
Interesting to note too is there is a cost in having an attorney, which we've had in the past, but there's also a cost of not having an attorney that you feel that you can go to when you're at odds or at differing opinions. And it would be interesting to calculate those costs if it's possible. I don't know if it were with the BRT thing, but to calculate the cost of not feeling like you could go to legal counsel on some of those issues. I don't know. It might be.
I don't think they're hard costs, but I understand the costs.
Psychological costs.
But
or
they're
emotional
hard costs too, I think. I don't know. But anyway.
Let's move to item 6.
I mean, just one brief final comment. I just wanted to say that I think this has been a great conversation. It's made me aware of, issues that it sounds like have been unresolved that I wasn't even aware existed in the first place, which is good. And to Mayor Stewart's point, I have been uncomfortable up here. Not that it makes a difference one way or another, but my discomfort isn't really with regard to the conflict question as much as it is to the quality of representation issue, which I'm recognizing that in these early first couple months that there were some concerns about that I wasn't aware of. So, but again, to kind of repeat what the mayor said before, there's no benefit to me of holding this position other than the satisfaction of trying to do a good job for you. And as we've discussed in the retreat at the beginning of the year, and a couple of times since, I serve because the council asked me to serve. I enjoy working with all of you, and I try to do the best that I can. But to the degree that there's any issues with that cause you frustration, I hope we can communicate openly about those. And if there's a decision made to go into that's totally fine. I think that all the policy issues that have been raised are valid concerns.
Thank you.
If I may say one more thing. For me, it was never an issue of you as a person or your professionalism or your ability to do your job, other than the fact that you're in the position that you're in. And you have 2 different entities that you have to answer to, and it's just a product of your position, really, where you're at. And I didn't come to you, but and it wasn't like I've been carrying these unresolved issues, other than the fact that I feel strongly that we do need separate counsel for the council. And I guess just not because of you as a person, it's because of the position we put you in, and you've said it yourself. You're kind of, you're juggling 2 different entities, and when we're all agreeable, it's fine. But when we disagree, that's when it gets really difficult. And we just happened to start out with an issue that was a hot button issue that we disagreed on. So anyway, just so you know, that's what I meant.
Mr. Sewell, to item 6, please.
Thank you, Mr. Chair. So several years ago, we had an issue in Provo with an ethical complaint against a council member. And I believe partly as a result of that, or mostly as a result of that, the state passed a law that created a state-level ethics commission to review these types of complaints. I guess there was some feedback that it was awkward and there wasn't really a good mechanism in place several years prior before this was passed to deal with those kind of complaints. So we became aware that some cities in the area, Orem, Springville, I think, and several others, are contemplating going another route to address this. This state ordinance allows the option for cities to create their own Ethics Commission. And so there's basically three options that we saw to handle these types of complaints. One is to rely on the existing state commission. One is to create a city-level ethics commission. And the third is what some cities in Utah County are doing, which is creating an interlocal commission, which is an agreement of 4 or 5 or 6 or 7 cities to kind of cooperate together in creating a regional type of commission. So I think this got started when we heard about Warren's interest in going the interlocal commission route. And in one of our joint meetings, we asked them about that and what they saw as the advantages of that versus using the state commission. And so I'll start with that one first. They mentioned the 3 reasons that they had for wanting to go down that route. They felt it gave them more local control. They felt that they could probably get issues handled more quickly. And then they mentioned kind of a cultural issue as well, where the people hearing the complaints would be from Utah County and maybe a little more culturally attuned, perhaps, than people from other areas of the state that might be different. So we started down that road, investigating that. It looked like it had some advantages. Then we had the good fortune of being able to speak with one of the citizens who've been involved in the original Provo issue, spent a lot of time on it, Diane Christensen, and she gave us a lot of good feedback. And one of the things that came up during that discussion was the idea that the state commission is more diverse, whereas the interlocal commission, at least as it's currently proposed, would consist only of attorneys. And she felt that having not only attorneys, but maybe retired judges, just people from different walks of life in the community as part of the commission would be valuable. As we looked at the local, the city-specific possibility, that had the advantages of diversity, but we could create a commission similar to the state commission, but there'd be more cost. And then there's the issue of maybe no people that are being developed very well, so you may have to enroll the commission members or that sort of thing. So the way these 2 alternatives, we've kind of come full circle in thinking that that we'd like to recommend that we or at least that you consider, we as a council consider staying with using the state commission. That would be the lowest cost option. It's already set up. It's composed of a diverse group. They've started to get a few complaints, so there's a process already in place. That's kind of the summary in a nutshell.
May I ask why you felt it necessary to identify one only, as opposed to leaving in the widest case all 3 as alternatives to the council?
That is certainly a possibility. And in fact, if you do create a city-specific commission, they can choose to pass a complaint on to the state commission, or a citizen that has a complaint could choose, if they didn't feel comfortable with taking it to a city-level commission, they could take it directly to the state commission as well. One other issue that came up is we just weren't sure there would be enough complaints for a single city to warrant having that extra level.
Yeah, and it may not be a standing committee per se, but these are, I see them, options available to the council.
Yes.
Depending on the case at hand. And so the local, shall we say, municipal ethics commission might very well be ad hoc, that is created should that option be exercised by the council, rather than requiring it to be a standing committee with some kind of semi-permanent membership.
Chairman, if I might interject, the one issue there, though, is that the state commission is created by state ordinance, and that state, or by state statute, and that state statute dictates that if there is not a city ordinance creating a local commission, then the state ethics commission is where the complaints go. So you could, just to clarify maybe what you might mean by ad hoc, you could react to a complaint by creating a local commission, but you would have to go through the process of creating an ordinance establishing the commission before the commission would have jurisdiction to hear
Or
the complaint.
would it be possible to create an ordinance that simply makes that option available to the council?
Certainly.
Yeah. And that's what I wonder, if you might be willing to consider simply allowing the council to have access to all three options, depending on the case at hand.
And as far as the immediacy of the decision, we just had in front of us a fairly current opportunity to consider the interlocal agreement that other cities were in the process of engaging in. So that's not to say it couldn't be joined at any time, but at that time it's something that was being looked at by others.
Right.
And with regard to keeping all three options open, I can't speak for the other cities, obviously. I don't know how they would react to this. There may be some reluctance on their part to allow us to join the interlocal commission if it's not complete to join.
Unless we pledge to that and only that option.
Right, because it would raise an issue where we would be, well, it would depend on how the agreement would read, but it could raise an issue of where there could be some inequities created if we're only kind of part of the commission and aren't participating fully. But I don't know how the other cities feel.
Fair enough.
Would it be possible to ask Brian to define two things? What gets considered and what doesn't? What's the difference between something that the city would pursue legally versus something that goes to this commission? And ultimately, is it an administrative or a council decision to pursue that?
Well, I would probably classify it as neither. And what I mean by that is the state commission exists, it's been created, it's been mandated by state ordinance, and it's been given jurisdiction to hear complaints of the Municipal Employees and Officials Ethics Act. So the only thing that commission does is it would hear complaints against municipal employees, appointed officials, and elected officials if they are accused of violating specific provisions of the Municipal Officials and Employees Ethics Act. So in other words, if they're accused of using their official position for personal gain, or disclosing confidential information that they gain through their official position for personal gain, or for receiving or soliciting inappropriate gifts, or failing to disclose that they were assisting an outside entity or person in a transaction, or that they had an interest in a business that was regulated or doing business with the city. So it's only those specific issues that are encompassed within the act that the commission would hear. And unless there's a city ordinance that says otherwise, the citizen who has the complaint would by state law file a complaint with the commission. Right. So the city wouldn't even be involved, essentially. The citizen would just file a complaint with the state commission, and they would conduct an investigation and issue a report.
If I may just bring up two examples that were extremely awkward. One was the Steve Turley one, where somehow I had to grant the stewardship resolving that without the local or state commission. No directions, no help from ordinance or anything. And the second, probably more awkward, is when I was the subject of the complaint and was charged resolving that, and had a citizen been given the ability to not be dependent on me and go directly to the state. I think they would have felt a lot better about that process.
Do either of you gentlemen have a recommendation to make in terms of whether to study this further or to vote on the proposal that you've made?
Well, we have a suggestion that I thought had some merit for us to consider. Actually, two things. One is that we do something on the city website to sort of inform citizens of this option to take complaints, because to the state commission. Probably a lot of people don't even know about that.
Right.
So that's a simple thing that we could look at. And the other suggestion that I heard that I thought we ought to consider at least was maybe a resolution, or perhaps a joint resolution, if the mayor agreed, just stating that we've considered these three possibilities, and that for the time being that we've felt that this is the most efficient way to handle it.
Just Mr. Winston, as far as stepping out to the state, did you guys find out anything? It's kind of like keeping things in house and say, okay, we have a problem here, let's fix it amongst the family with the interlocal agreement. Is there any advantages that you saw to keeping it in a local type situation versus, and what would they be? Did you happen to see? Yeah, just a question, David.
Well, one of them that I think it was Jamie Davis had mentioned in the meeting that they felt there was some advantage to that, where you would be dealing with attorneys from cities that were relatively close and sort of aware of culture and situations in Utah County.
They thought that input responses could be provided more quickly, in a more timely fashion. But I don't know that anyone has experience to show otherwise, you know.
Not yet.
And the other question that I had to do with cost. And the cost, it seemed like with the interlocal agreement would be the cost of our attorneys participating. It's not, it's a time cost that we would lose their services because they're dealing with an ethics outside of our city.
Right.
But as far as hard cost, dollars and cents, we're not writing checks or anything like that to participate in either of these situations, right?
That's correct.
Okay.
Just a comment. Who would cover, there must be some cost of secretary or paperwork or some kind of clerical cost. Is that interlocal commission has that organization, and they, so I'm assuming there have to be some hard cost.
For whoever's chairing it at that particular issue.
They share each year with the charity, or?
Understanding is that when the interlocal group is brought together, it's comprised of the cities that aren't part of the complaint, and that's when you would accrue some costs relative to staff time, maybe some administrative time as well, but not outside of a complaint being filed.
In other words, apparently the body doesn't employ its own staff.
Right.
Independent of the staff's already in place in various city attorney's offices.
So, Mr. Jones,
Please.
Mr. Jones, would there be like hard costs incurred if you, say you were chair of the group for that particular time, it would be your hours, and then would there be, can you foresee hard costs that would be incurred?
Well, probably not in terms of what we traditionally think of hard costs. I mean, we'd probably end up copying a whole bunch of paper, and that would end up just coming out of the legal office budget, right? And we may have to, borrow the council's recording equipment in order to record interviews. We did that in one of the previous investigations. And so there's equipment and staffing resources being used, but I would think that 99% of those, if not all of them, would be just internal to the city and would just result in some costs of those things being invested in the investigation and the review rather than something else.
Do you have an opinion on whether that would be workable for given your caseload and given something that would be feasible?
Yeah, I think it's certainly feasible. I mean, we've done an investigation in the past. It is a time sink. I mean, the investigation that the mayor referred to a few moments ago, it wasn't even really a particularly complex issue. It only involved interviewing 4 or 5 people, and it probably still took, 20 to 40 hours of staff time to generate a final report on that. So it's not an insignificant amount of resources or devotion of resources On the other hand, my anticipation would be that there would be very few of these. We could even go years before we had to respond to one. And so during the time that the investigation, and I guess I should say, so that's one end of the spectrum. On the other end of the spectrum, the Turley matter was very complex, right? And that, the amount of, we had the binders and binders of material and dozens of witnesses, and so something like that could be very significant as far as the resources needed. But I think it's all manageable, but there's benefit costs of setting aside those resources for this as compared to something else that could be working. It's not unworkable, but it'll be an impact.
Mr. Hales?
I was just wondering if it would be an advantage not to have somebody who was familiar with the local culture investigating this. I mean, it's
That's a question too. Is local culture really in?
I had one comment about that. We've discussed several times the makeup of the commission, but I don't know that we've ever, maybe I missed it if we have, I'm not sure we've ever actually discussed the makeup of the state commission, just so as a body you know what that is. But it consists, by state statute, it's a 7-member panel. It consists of 1 member who has been but is no longer a judge, 1 member who has been but not for at least 4 years been either a mayor or a member of the municipal council, 1 member who must have been a member of a local board of education. So that's 3 of the members. Then 2 lay members that have no requirements as far as position, and then 2 more members that must have been either a mayor, a council member, a county commissioner, a special service district board member, a board of trustees member, or a judge. So 5 of the people on the 7-person commission must be former experienced members of city or local government or judges, and then 2 laypersons.
I noticed that Paul Warner is on the list, and if it were a Provo issue, would he be recused, or would he be able to still do it if it were a Provo? And I'm assuming that's the same Paul Warner that was a council member here.
That is an excellent question.
It may not be.
So it may
There's a
not.
former judge, Paul Warner.
Oh, is there a former judge named Paul Warner? It looked like it was under mayor and council member. It's on the list.
Could well be.
But just a question in general is if it were a Provo person have to be on the panel, would they accuse themselves if it were someone from Provo, or would they still be part of it?
I don't actually remember the answer to that off the top of my head, but I can look at the statute briefly.
Now go back to this argument of if you're Provo, that's an advantage in one area, but now we're going to recuse them if it's on the state commission. So it's kind of.
Mr. Chair, our committee then will move forward with preparing a joint resolution in favor of the state commission, but inviting input from council members between now and the next 2 weeks, in case there are some things that we've missed that we ought to take into consideration.
Including the 2 items you raised most recently. Fine, perfect. Okay. Thank you.
And I think that the planning system gave some valuable input to cost savings, and you mentioned a few different things with the state options.
Thank you. Let's now move to item 3, a discussion on a resolution of protest regarding the pending annexation of approximately 227.96 acres of land located generally north of 2000 north and west of I-15 pursuant to Utah State Code 10-2-407. Mr. Harvey.
Thank you, Chair Miller, members of council. I will make this very quick. I know we're behind. Essentially, there's an annexation petition that was submitted by someone in the city of Orem. Orem is required once they receive that, send it out to all the neighboring entities. So we received that, a letter advising us of this annexation. The majority of the annexation, this solid line, it's kind of hard to see, but the solid line here is the entire annexation. This street right here is Geneva Road. I-15 is over here. And the majority of the annexation is okay, we don't have any problem. The only problem we have is this little sliver right here, west of Geneva Road on 2000 North, Provo, or if you're from Orem, it's 2000 South. We have actually claimed that in conversations with the city of Orem, have agreed in informal conversations that we would have possession of that entire road. It's also a part of the annexation policy map. It's part of the general plan. And so that the annexation as submitted has that road included in it. And so that's what we were protesting. The process is we submit a protest that goes to the Boundary Commission. They come back with their finding, and then Orem City goes forward with it after they have to wait until they receive the findings from the Boundary Commission. So that's about it. So if you have any questions, I'll be free to.
It looks to me, as I look at that map, it seems to me that almost is a survey. And the way that's shaped, when I look at the county maps in other areas, it looks to me like there's a starting point at the beginning of something that should actually shift that up. But also, from what I understand, this little piece down here that we're getting subdivides some properties, not only the road, but it subsidized properties. And I just hate to see parcels.
Yeah, the road's great.
There could always be disputes on values and things like that. I would like to see that going actually to a road, so I agree with that.
That is correct.
Other questions, please, Mr. Manager?
I guess, Ryan, what's been the argument to bring that in with the rest of it?
It's I don't think it's anything that the petition was submitted not by the city, right? It was an applicant that submitted the petition. So I don't think that Orem is trying to capture that. It's just how it was submitted. And so as part of the process, we're saying, no, we made this agreement that this is not going to be part of it. So the applicant didn't make any argument as to why that road.
I mean, they're not trying to, 2000 South or North probably is not going to shift.
Right, yeah.
So if you look at future road plans for the county or either of the communities, won't that vision continue to the west from Geneva Road? Or it seems like if it's annexed, the road would need to shift. So the division of the city would be on the road, not in the middle of the lot.
Yeah.
So I don't understand.
What is it that's being asked of us?
It's just in council meeting tonight, a formal resolution of protest. So we're required to say, we're required to submit this protest, and that's when it triggers, goes to the Boundary Commission, and they make their finding. So.
Ryan, is that line in the middle of the road, or is it the entire 2000 north south?
The road's actually up here.
I see.
So
the entire road is in.
So yeah,
okay.
How it's shown here, the entire road would actually go.
Clarification, that road's not constructed yet west of Geneva.
Well, there's a little, yeah, there's just,
Let's see
there's a
that
little tiny bit, but it's not constructed all the way to there.
the current line to the east, my understanding is that aligns with the northern end of the concrete or asphalt of that right of way. And so you can see how it jogs down.
You do have some, yeah.
Sorry, I'm David Day with Public Works. We have a graphic that kind of shows the design of Lakeview Parkway and 2000 North. It shows where that line would be if you'd like to look at it.
That one would be put in.
Yeah, it's that PDF.
Isn't that southeast corner of the Lakeview Fields property that we just barely?
Right where the whole jog is.
Right, off the
The right one.
That's the intersection of 2000 North and that.
Yeah.
Also, if you could kind of zoom in on that a little. Sorry. If you really want to see exactly where that alignment for that road is. You can see the red.
That's
is where
that's
that
the
boundary
current
boundary
boundary line right
exists.
now.
And this top of this green would be where we would propose that annexation end. And we would have to do an annexation going north to do that.
How many feet is the offset?
What's the width on that, Chad?
The right-of-way width is 86 feet, and then there's approximately 30 feet from the south right-of-way to the existing barn right there.
When this was designed, you can see this building right here. The Lakeview Parkway was designed so that it would not impact that building. It was just barely built. So they kept about a 30-foot offset. That kind of set the road alignment. Then it kind of swings back south to the intersection of the road.
Hey, has anybody talked with, I mean, this makes sense, right? Has anybody
Yeah,
talked with
yeah.
the why?
So
is this?
We've talked with Foreman. I've been on the phone with them today, and we've already have an agreement that this was going to be the case. It's just that this annexation proposal doesn't mix well with what we've already agreed to with Foreman.
Would we be filing our own petition at the same time?
That's what we hope to do. Is
For consideration by the same committee?
Yeah, we'll meet with Orem, we'll define that boundary and the road and all of that, and they can come back in with their petition to annex, and then we'll be fine with it.
Should that be part of the motion that's made in the later meeting?
I think, well, I was just going to say, certainly if you would like to clean it up now, it wouldn't go forward at this time to the boundary commission. It would start, if you were to try and capture that sliver of property in the interest of Provo, you'd certainly start your own annexation process, which if protested would go to the boundary commission. I think the boundary commission only convenes when there are protests.
Yeah, Orem felt like this was going to be a little bit of a process to realizing that we need to come back and annex that left.
So first we protest, then we petition.
Yeah.
Just by way of clarification, and Ryan mentioned this, that remember the annexation petition that we just had a few weeks ago. A petition is a document that comes from a private citizen. So there's annexation by petition, and then there's annexation by resolution. So this is an annexation by petition. So all that has happened so far is the private citizens filed a petition with Orem. Orem, as they are required to under statute, sent out notice to all the affected entities, and we're responding to make sure that it gets in front of the boundary commission. Then, as Matt indicated, if we want to go ahead and annex that now, or we can wait, at some point we would do a resolution.
Well, a resolution, not a petition.
Right.
Thank you.
Yeah. If I could, and this doesn't relate directly to this, but I am concerned because the citizen's name that came up on this spoke to me several months ago and is pushing for one development line to bring their sewer south into Provo. And we already, in a small area years ago, have taken approximately 152 units into our sewer system and about 115 water connections. And that's been fine, and that's not uncommon to do that. However, with what we're facing right now with infrastructure, and every unit that goes in there is one that takes away from what we can supply for Provo. And so the position is we're not wanting to take any more. And so I think with some of this as a crop site, just kind of waved the flag to me that perhaps they're going to be requesting, he wanted 350 units when he started talking to me at the time. And we just, we're not in a position to do that with the other commitments that we have out to other developments in Provo. So if you hear that somewhere along the line, and if that comes up in these discussions, at least at this point, our answer would be no.
Is it, are we saying this is not in the city at this point to the south end? It's in the county, all that, it's in the south, it's just in our annexation plan.
So all of this is in the county currently.
But that's what Orem wants to have.
Yes. Provo is up to the red line, so
That's within
the
our.
red
city
line
limits.
really needs to be moved up to the top of this.
That's not, yeah, and that's what I thought. So basically, if we're only going to the green line, we're not 350 units in there, that's over there, so we're not looking at that, increasing that.
No, it isn't that at all, it's just a way for individual petitioning for this. It's the same one talked to me earlier, finding another piece of property right closer there that he's wanting to bring that in. So Orem can't service that unless they build other infrastructure. And all I see is with some of this is kind of a posturing with what we're looking at. I think maybe they'll be bringing the sewer back towards us and then us supplying the water. That's not something
The area is probably right here for the 350 homes and they would tie into our sewer that already exists.
Yeah.
From Orem to tie into Provo sewer.
And that's, in essence, that's what we're protesting.
Okay, gotcha.
But the question is, in lodging the protest with the boundary commission, are we providing our reasons for doing so? Will they be informed about the issues that you've raised?
I'm not sure, maybe Brian could elaborate on
Yes,
that. How that's
the resolution that's up for consideration tonight lays out those reasons in summary, and then to an extent, additional information will go then to lay it out.
And it's not like I don't think we're offending Orem by protesting, because that sounds kind of drastic, a protest, but it's
just a legal
the way it works. And so they're aware that we're protesting it because of the line issue at 2000 North. And what we have discussed with them is that the north edge of that right of way of the road would be all in the Provo line, so Provo would own and maintain 2000 west of the freeway.
There's a quick answer. When the property was annexed to Provo, to south now, and knowing the road line was opposed to 2000, how come the annexation, a little bit of battle didn't take place? Why was there a little sliver left? If there's a quick answer.
There's not.
Silly you,
expecting
a quick answer.
The quick answer is that line was not drawn by an engineer or a surveyor. It was just put in there just to kind of as a placeholder to say this is approximately where we're going to be. And now we
your point.
We didn't hear you.
We'll have a ruler.
Yeah.
Mayor Stewart was mayor.
So, who's currently providing sewer for the county, just along 2000?
There isn't anything along there.
They are on
The only
septic.
thing We are, as you go east between Geneva Road and I-15, we're coming into our system there, and then a line comes down across the Geneva Road with small capacity, and that's part of where Broadview Shore is coming in. We've got to have a lift station, force main, and expanded facilities there. And the gentleman that spoke to me brought out that he knew we were coming up Geneva Road with developments, and he was expecting to be able to come into that. And we're saying no, with the commitments we have, we're concerned about capacity issues. Not like now, but every unit we take away, every unit that goes to Orem to come here, that's somebody we can't service as well.
Any further questions? We look forward to the item later, in our later meeting. Thank you. Now to Mr. Mumford. Discussion on a resolution amending the Provo City General Plan to include a section entitled Neighborhood Plans.
Thank you, Mr. Chair, Council. Just to provide a little background on the issue, Objective 2.1.1 of Vision 2030 states, identify exceptional areas that would benefit from area-specific master plans where the city would conduct a detailed land use analysis. The objective is for a plan for every neighborhood. And so if you recall, on July 15th, you passed the Joaquin Neighborhood Plan, and that was put into the general plan. There are more plans coming down the pipe,
And so for that reason, we want to have a dedicated area so that these neighborhood plans aren't scattered throughout the general plan. And so this requires a general plan amendment, which requires action from the Planning Commission. And so we need formal council action to allow us to move this to the Planning Commission so that we can create a holding place for these neighborhood plans. So that's
Questions? Comments? Thank you kindly.
So what we're asking for today is a motion, just simply authorizing council staff to make an application to this effect.
So it's not on the agenda already.
No, this would be the, again, it's just authorizing us to move forward.
I invite the motion. Ms. Santiago, a second. Mr. Sewell, all in favor? That motion passes unanimously. Thank you.
Was that clear as much, please? Yes, it's very clear. Okay.
We now invite Dustin Wright from the Planning Department to lead a consideration, a review of plans for proposed funeral home located at 4800 North University Avenue. Welcome.
Chair and council. So this is a property that the city has entered into agreements with the applicant, has sold the property, and as part of the real estate purchase contract, maintain the final option to be able to approve the materials and architecture that will be used for this funeral home. And so during the process, it's been through the design review committee, received approval from them, and as it's gone through the process further, we've received some revisions to those materials and a little bit of the architecture. But still, the council has the final determination on what is approved for those materials, and the architect and the applicant are here as well if there's any questions.
Mr. Wright, the council hasn't received any materials, elevations, or pictures of photos rendering. And just to refresh council members' memories, and maybe council members that were not present on the purpose of why we're even having this meeting. The property at 4800 North, city-owned in between the university and the Foothill Drive connection, was sold with a condition from the council that prior to final closing of all the documents, the council would have the ability to review and give feedback on the final elevations. So that's the purpose, is just there's no formal action that needs to happen per se. You're certainly welcome to if you'd like to. But the purpose of this is to get that review and feedback so that they can finalize the transaction.
So let's invite the architect and project coordinator, whomever else might be here, make a presentation.
Do we have any illustrations?
I believe that they were going to provide some material boards today. Is that?
I'm Gil Rand, I'm the architect. I thought that you would have all those things here on the screen.
I see. So we'll continue this.
Just call the office and have them here within a half an hour.
I have the materials board from the previously approved stuff from the years.
But not the latest.
But not the most current materials. So.
I recommend that we table this until 2 weeks hence and be informed about it then.
Can you tell us if there are any time sensitivity issues with this?
I'm sorry.
If the council postpones this 2 weeks, is that a hardship from a time perspective?
No, I think it's be all right. Okay, I will get those things back, and who do I need to get them to?
What's that motion? Yes, I invite a motion to continue. Mr. Van Buren, a second. Thank you, Mr. Winterton. All in favor? The motion passes unanimously. And now to Mr. Gary Bushman for a discussion of a resolution approving and adopting a restatement of the health reimbursement arrangement plan. Welcome.
Thank you, Council Chair. Council members. Every few years, the city needs to update
what we call the cafeteria plan. This is the plan which we operate our city benefits under the IRS tax code, known as 125C, that allows us to provide benefits and employees to enjoy those benefits on a tax-free basis. And so before you is a resolution to adopt a restatement of that plan. And the restatement is an update to federal law changes, things that we dealt with the Affordable Health Care Act, and that just keeps us in compliance. It also changes what our default plan is. If an employee fails to enroll in a particular plan, then we have a default plan that we automatically enroll in. Are there any questions about that plan?
Any changes to what you?
There is a.
I looked through, it's a fairly lengthy.
Yeah.
Plan.
This was a shorter document,
Okay.
and as I mentioned, the changes primarily pertain to the default plan that an employee would go into if they fail to elect, and we have to throw in a plan. And also we changed a title for the position of who our person is who's in charge of protecting personal health information in the city.
Peters, is there anything that you wish to mention?
May I use this opportunity just to give a shout out to really the whole Human Resource Department. They are cutting edge with our health insurance plan. They are way out ahead of the rest of the state and recently made some changes that involve massive amounts of work but have dramatically improved health insurance coverage and reduced costs to the city. So just give them a shout out.
Here. A motion then to take this matter to the council meeting agenda 2 weeks hence. So moved. Mr. Garrett, thank you. A second. Mr. Hales, all in favor? Okay, that motion passes unanimously. Thank you, Mr. Bushman.
The second one is the HRA.
Yes. A discussion on a resolution approving and adopting a restatement of the health reimbursement arrangement plan for the cafeteria.
This would just be the health reimbursement account plan. And this is some years ago, the city, when the IRS approved a health reimbursement arrangement, we were the first municipality that I'm aware of in the nation to adopt it. We were written up in a lot of magazines. We were kind of thinking on this. And when we put it into place, we actually designed it differently than the IRS intended it. We designed it to walk and talk like an HSA before we knew what an HSA was, a health savings account. And as the years evolved, the IRS developed the HSA, which made the HRA less desirable. The part that's less desirable about that HRA is that an employee cannot contribute money to it. They have to put their money into a flexible spending account, which is an FSA, but that account is a use it or lose it proposition. And we're always trying to encourage our employees to put money in and save it. And so when the HSA came along, we have moved our employees to that plan. And then last year when we elected to go into the merchant market exchange, one of the first municipalities, I believe, in the country to go into a private healthcare exchange, the redesign of that created an opportunity for us to move directly to the HSA and not continue supporting or funding the HRA. And the purpose of this restatement is to do a couple of things. One, it is to terminate the plan effective January 1st. Now you'll note on both this document and the previous document, the effective date is January 1st of 2014. We're allowed to make the change anytime during the year, and it can be effective in the first year, but we have to do it before the plan year is over. So what we're proposing with this HRA is we are terminating the plan, but with that termination, now most entities that have an HRA, that's employer-owned money, and the money just goes away and the employee doesn't get it. But with the Provo City, we told the employees that we would vest that to them if they save the money. And even when they left the city, if they had 2 years in the plan, we'd let them take that with them. So what we're proposing with this restatement is to terminate the plan and then provide a mechanism for existing employees and terminated employees to cash that money out. And the law doesn't provide a direct rollover, but it does allow us, we would take that money, put it in their paycheck, treat it as income, but we would give the employee opportunity at that time that if they wanted to take money from that check and direct money to an HSA or a 401k or any deferred savings plan, that they had that choice. So they would have a number of choices. So the essence of the plan is that once it's approved by the council, we will provide the form to the employees that are still in the plan. They will have 31 days to provide the money once they submit the form. At the end of the year, if they have not submitted the form, then we'll do an automatic distribution to them within 31 days. Now, we have some employees that might have a claim like on the last day of the month of December, so we try to accommodate that by saying, if you will tell us by January 15th that you have a claim coming in, we will give you an extension 31 days from 15. So we're trying to accommodate, not create a problem for people. So they can use the money up or they can take a distribution between now and the end of the year.
So this is all employee money. Is there any financial impact to the city?
Yes, there is for those, a couple of impacts. One is that the city continues to pay a maintenance fee, a monthly maintenance fee on every active account we have out there. It was about $3 or $4 a month. And that would go per account, and that would go away. And those vested employees, we have individuals who have that money sitting up that have not used it for years that are vested, and they haven't been aware of it. For instance, we had a council member some time ago that was not using the money, but since they're no longer an active employee, that maintenance fee was coming out of their account, and it was slowly dwindling the account, and they were never using it. So they were getting the benefit of it. So it saves money for the employee that is worth the money in another, either in their HSA or cash, and it saves the city the money for maintaining the account.
Further questions? I'd like in a separate motion to place this item on the municipal council agenda 2 weeks hence. On the other, Mr. Hales, is second. All in favor? That motion passes unanimously. Thank you very much, Mr. Bushman and Ms. Elders. Mayor has absented. We'll come back to item 10. In the meantime, invite Sean Allen from the Planning Department to lead a discussion on a request for the vacation of public streets, 1540 East and a portion of Summit Drive, north of Ridge Drive, generally located at 1440 East Ridge Drive in the R1.10 one-family residential zone.
Mr. Allen's not here, so I'll recognize Mr. Day. Oh. Yeah.
Mr. Day, instead.
I don't look a whole lot like Sean, but I'm day-to-day with public works. Got a little graphic that hopefully kind of shows this. We try to color coordinate this with the mayor's socks, but
you came close.
So right here, that's the original plat via Foothill Park, is it as it was recorded. So then they came in and they wanted to adjust some of the lots and the roads in plat B, and they're calling that plat C. You go to, it's that shaded area. You can see that. Can you turn just that on? The reader's not letting me. Do you?
page right
There
there.
we go, all right. So this is flat. Which one do you want?
C. So you can see how that's a lot smaller.
Can you zoom into
it's
that?
a subset, so go back and turn it on B again. Yeah, let's make it as big as we can. And then turn on B. So hopefully you can kind of see how the C is totally a subset of B, but we have to vacate that portion of B where C now resides. So I hope that makes sense. So all of this area of C up that way is the part of B that's being vacated, and that's what we're talking about.
Mr. Day, I think specifically the action the council has to act on is actually the street vacation, not the plat vacation.
True.
And so there was some changes in the street layout, isn't that correct?
Yeah, so if you look at this road, there's a pointer.
This is originally what was part of Plat B.
So this road goes up like this. No, that's, yeah, so that road, and then there was another road up that went up to the detention area.
Are they even finished, those roads?
No, none of this is built. Well, they built the detention basin, but none of the roads have been built in C yet. Go.
I'll see you on.
Yeah.
Me too.
So I don't know if you can see that, how those, some of the old roads cut through some of the lots. And so when we took this to the county to record it, they felt like we needed to vacate the roads that went through lots and were no longer roads in order for us to be able to record the plat. So Matt's right, it's really just a vacation of any of these roads that cut through lots as part of this new configuration of lots.
And those are existing.
Yes.
So how do they then get to the lots? Are those larger lots up there that are just going to get accessed by that road that goes to the west?
Thank you. Yeah, so turn on C, how it's...
Yeah. And so how would you get to it?
And then turn off B. Because B will show the wrong roads. So now it ends up being a cul-de-sac and then a road up going up top here.
Okay.
It was actually a better fit for, I think, everyone. The retaining walls on this subdivision went from 30 feet down to about 20 feet. So it changed that. It also made the lot configurations work better, and then the access up to the detention basin and the Foothill Park a lot better. So.
And then where they exit, what street? They're kind of to Arlington, just north of Arlington?
Yeah, Seven Peaks Boulevard ties in. That was part of Plat B. That's not being modified at all.
What about the cul-de-sac? Where would they exit? Just down?
The cul-de-sac would come down to Summit, right here. Yeah. This road didn't change. So it's mainly just making that one. That through road is now a cul-de-sac, and this upper road is now a cul-de-sac.
Does that St. George Boulevard, does it connect? What does it connect to? 1450? It'll go all the way to 1450.
Eventually 1450.
Yeah. That's on our capital improvement plan for in the future. We are, however, tying in a water line all the way up to 1450 to give pressure to the upper lots in this area. So you'll see some work going all the way up along that alignment. It'll be about a 15-foot wide path through there.
But the road's scheduled for years now.
Yeah, it's about a $1.5 million project. That in my budget is in here. It's not in there this year.
Any questions, Mr. Van Buren? Thank you, Mr. Day.
Okay.
Would you kindly turn those lights on as you pass by? Thank you, Mr. McGinn. I find a motion to place this item on the municipal council agenda 2 weeks hence. Mr. Garrett, thank you. Mr. Winterton, second. All in favor? Thank you. The motion passes unanimously. Mayor Curtis.
Aye. That's what my wife does when I say I was wrong.
You have 10 minutes.
I will defer my 10 minutes to other group.
With such notable color coordination.
You can take 10 minutes on socks.
It's my understanding, Mr. Taylor, that item 12 there is a request to continue that to...
Indefinitely.
Oh, indefinitely.
Or you want to go withdraw, Gary? That was a different issue. Request.
Mr. McGinn.
If we could withdraw, what happened is some amendments went to the planning commission. After the planning commission made a recommendation to the council, as staff, we got together and looked at it and said, we didn't do our best work on this. We want to make some additional changes to it. It got put on the council's agenda. What we'd actually like to do is we tweak that, but those were some things that the planning commission didn't see. So we thought it'd be more appropriate to go back to the planning commission. And so in the future, so we'll just withdraw this, but we'll go have another hearing at the planning commission, and we'll come back shortly. We just wanted, we felt it was important to go back to the planning commission, and from their recommendation, say, look, we would like to change it a little more before we go to council, and make sure they understood rather than making changes and just coming to the council.
All to do with the consolidated fee schedule.
Well, not all with the consolidated fee. So there's some other things in there that we were dealing with. And so that's what we'd like to do. So we'd just like to withdraw this. We'll be going to the planning commission here in August, and then we'll be following the normal process from there. So in September, October, you'll see this. There's nothing time sensitive on it.
Thank you.
It's clean up.
Thank you. And now to Mr. Pepperoni. Item 13, a discussion of a proposal from the Neighborhood Housing Services of Provo, Purchase Redevelopment Agency, property located at 590 South, 400 West.
Slide on the council. You want to use that? Slide on the
So waiting for the slide to go up, but there's the property is just over an acre, 1.1 acres, just south of the property already owned by NeighborWorks, along 500 South and 400 West. NeighborWorks has submitted to us a contract for purchase of that. Showing that NeighborWorks is here, and probably best or most appropriate if she went through kind of what they have in mind, what they're proposing, and description of their project. The city owns, the redevelopment agency owns the south portion of this, which is the 1.1 acres. That includes a small piece that comes out the road here, the property there. NeighborWorks, that's the piece that they own.
I have done it for some time. The city has owned this since about 2001. RD has owned it since 2001. Both these properties are currently zoned NITOD, ITOD. And that is the border of the ITOD zone. This property is the CM, commercial manufacturing zone. But with just that brief description, I'd like to turn it over to Charlene to explain to you what they propose to do.
Thank you. Council Chair, and, excuse me, RDA Board. I am Charlene Wild, Executive Director of Neighborhood Housing Services, now NeighborWorks Provo. We are proposing to do a development on this property and would like to develop the two parcels together, the one that NeighborWorks Provo currently owns at 510 and 532 South, 400 West, and we would like to purchase 590 South and 400 West from the Provo RDA agency. We would propose that, to put a multifamily development on this property. We would like to construct 80 multifamily units. These units are 2, 3, and 4 bedroom units. They are designed to house families. There are no efficiency or 1 bedroom units in this development. The smaller units are approximately 820 square feet, with the larger units clear up to 1,220 square feet, which is sufficient to house a nice sized family, as we tend to have here in Utah. We have sufficient parking, and however, we are in very, very early preliminary stages. And we have talked to the neighborhood chair and the assistant chair, and they have not only voiced some of their concerns, but also given us some really great ideas as to some things that we can do to make this something that the neighborhood would be proud of. We are on the neighborhood meeting agenda tomorrow to talk to the neighborhood and try to make this a nice development that they'll be proud of, that they'll enjoy living around, and take their ideas and make sure that we try to address any concerns that they may have. This is a tax credit deal, and there is a certain portion of the development that will be income qualified. However, we currently have 31 rental units that we manage at this point, and we have everything from full-time school teachers to police officers to people from the hospital, and we have all sorts of people. We have bankers from Wells Fargo Bank that rent from us. We have a lot of really amazing people that still, though they have large enough families that they are income qualified, they are great people to have in the neighborhoods. Is there anything else that I can answer for you at this time, because it is so early in the design phase? The reason that we are asking for this rather quickly is that we have the opportunity for funding that only came to light about the latter part of April, first part of May. And we didn't realize, we've had this property for 10 years. I looked it up this morning and I went, oh my goodness, I can't believe that we've had this property this long. But we have had it for 10 years, and it's probably time to do something. But we just learned of some of this funding that was available that has not been available to us in the past. And we do want to seize the opportunity to take advantage of that. There are some time deadline elements that I am facing that I may not be the top of the list, and without site control, we immediately drop to the bottom of the funding list and possibly are disqualified. So that's why I'm respectfully asking the redevelopment agency board to consider our offer and in light of this, so that we don't lose out on the opportunity to bring this money to Provo.
Just a comment. I talked to the neighborhood chair, and just to make sure that the neighborhood feels good about it. And originally they were opposed to income-related housing projects, but in this particular case, they're very much in favor. So thank you for talking through that with them and making sure that they felt good about it. One of the things that they're concerned about is they have tremendous trust in you. And so 50 years from now, when you retire, they want to make sure that it will continue to be, an adequately supervised project. And I told them that I was confident you would be able to do that.
We have that in writing.
Or is that another resolution?
Councilman Hales, I really don't want to stay that long, but and I so appreciate that trust and faith that the neighborhood has in our organization. Kind of think that we have some pretty amazing board members, and without their guidance, they all live here, most of them, and these are the friends and neighbors that sit on my board, and so I believe that they honestly not only guide our organization from a practical standpoint, but from their heart.
But you have some standards as well that you
We
feel
do.
like are going to continue.
And I really want to tell you about that. We not only screen our tenants, and it is a worry, trust me, I check for gray hairs regularly, because we only take about 1 in every 10 applications, because they just don't get through our screening process. They have to pass a background check. Income qualified is probably one small portion of what we screen for. They cannot have any criminal record on their background short of a speeding citation, or maybe they got into a fisticuffs when they were 15. But that, seriously, there is nothing, at school. We just don't allow that. They do all have to have an appropriate landlord screening, so we do call over landlords. Sometimes the landlords are mad when they're moving, so I'm not going to tell you that sometimes they don't get, they don't say something but nothing that would alarm us. They do all have to be United States citizens, and every belly button that's in the home has to be a U.S. citizen, and that is not our regulation. That is federal regulation based on the funding that we use. And so we've adopted that. We go to their current home and inspect their current home. Is there damage? Do we see evidence of cleaning supplies? Is there cars up on blocks? Is there a couch on the front porch? I can name things that we've all seen and that we don't appreciate. And so in this particular instance, they wouldn't be responsible for yards, but we do stay on top of that as well. And so we really do screen them. The other thing that I think that we are different in, and I am really, really excited about, is the education piece that we are going to not offer, but insist upon. We call it our up and out self-sufficiency program. That is up into middle class and out of tenancy and into homeownership. And in this class, there are 3 pieces. The first part they have to take before we ever get to the keys. It's about an 8-hour class. They will learn about credit. They will learn about how to do a budget. They will learn how to be a good neighbor. They will learn that they have to vacuum their floor every week. There's just things that a lot of people do not know. It's very commonplace for us, but young people starting out don't know that. They will take that 8-hour class, and then for the next 12 months at least, they have to agree to be in a counseling program where they will bring in their own personal budget, and they will work with a HUD-certified counselor, which we have 2 on staff. And every other month, we will go through their budget and see how they're doing. They will learn how credit is affecting them. We have a software program that will help them increase their credit score. They will learn how to save. There's all sorts of things that they learn. And if they seem to be progressing nicely over 12 months, then they can get out of the program and continue on in their own way. People tend to get really excited about these kinds of things in the first 2 months, and then they find that it is a little bit of work, and they back off, and we're not going to allow that to happen. And last but not least, they are required to take our homebuyer education class, and this teaches them about the home buying process and how to actually move into ownership. We just received word yesterday that one of the banks has offered to, we already have a portion of this in place, but they are writing us a check for $10,000 to develop the curriculum to finish this out. So it is fully funded. We are ready to go.
Thank you.
Mr. Van Buren.
Can you, which funding program is it that we use on this?
Pardon?
Which funding program is it a donor funding?
There are several. There's we have a tax credits. We're looking at 9% tax credits. There's NeighborWorks America funds. There's Federal Home Loan Bank funds. There's some state appropriations for TOD areas. There's some private funding that is offered at this point. And so there's 5 layers with 2 backup layers, just in case. We are looking at the Open Walker Housing Trust Fund. There's several layers. We have actually hired a bond consultant to help us bring this project together, and it appears to be about $11.5 to $12 million.
Mr. Whitaker.
You have 31 units that you rent out now, is that what you said?
That's correct.
And who manages those?
We do.
And you do, and you hire subcontractors to take care of challenges?
That's correct, yes, and I do have full-time maintenance.
And you've got full-time maintenance staff. Have you ever sold any units? I mean, you've got 31 now. Have you ever sold units? I think one of the concerns is there's 50 years that you committed to. Is that if we get another group, if you said, oh, this isn't working out for us, you sell it to another group, they may not have the oversight that you have.
That we have.
Have you ever sold units?
No, we have never sold any of our units that we intended to keep as rentals, no. But we do not, it is our intent, according to my board, that this is ours. We intend to keep it into perpetuity.
And did you say all 80 units are income qualified?
No, they are not.
What are the percentages?
There's 80% that are income qualified, and there are 20% that are market. Our special target group would be veterans. As per the tax code, the housing tax credits, you have to have a special market group that you kind of target, and we will reserve at least 5 units for veterans. And we have to actually actively work with the Veterans Administration and other organizations that serve veterans to try to bring them into our development. They're the target that we've chosen.
Mayor Curtis.
And if you explain this, I'm sorry I missed it, but could you explain the restrictions on the property that you own?
Yes, when we were asked to purchase the property by Provo City, we were provided funding to do so, and from what I understand from Hoglaser, this funding has to be, it was for affordable housing, and therefore the portion that we have has to be affordable housing. It cannot be anything else. The progressive manufacturer has tried to purchase it, and the city's informing that we could not sell it because it had to go to affordable housing.
You could not sell it to some other investor?
We could sell it if they were willing to do affordable housing.
It has to be affordable.
But it has to be affordable housing. I was not allowed to sell it to progressive.
So you own the property just to the north?
Correct.
To the north as well, that you've redeveloped?
Yes, we did Franklin Commons, and that was actually pretty well, we were just bringing basements up out of the ground when they hired me 11 years ago. And, but they demolished 8 homes and a Japanese mechanic shop right there because they felt like it had deteriorated to a significant point that it needed to go. And so we built 17 units. And I drove down there today to just see what it looked like, and I was so pleased. And I can't take credit for this because it's all the residents there. It looks beautiful. It looks manicured, and it is just, it's beautiful there. 10 years later, is gorgeous.
It does look really nice, and they're all owned by individual.
They are. I believe that there may be one or two tenants that live in there, but they're all families. I don't know, honestly. Kim, I don't know. I know that our original intent was all homeowners, and we did so. It's really beautiful.
Mr. Winterton.
Can you tell me what actually affordable housing means? And also, can you tell us a little bit about your board?
Sure.
I think as council members would be interested.
Sure. Affordable housing can mean a multitude of different things. Affordable housing can be 80% below AMI. And for a family of 4 in Provo, AMI, 100% of AMI is $64,200.
Family of 4.
Family of 4. And that's kind of, what we all use as a benchmark. Family of 6 is actually what my tenants tend to bring to the table is 5 and 6. But family of 4, $64,200. Tax credits are generally 60% and below. Okay? And so most tax credit projects are 60%, some are 50%, some are 45% and below AMI. Now, at a family of 4, some family that's earning about $15 and they've got 2 kids could qualify to live here and help. Now, that is what not a teller at any of your local banks make, but your bankers. You walk in and ask for a car loan, right? And most of them are young. They get younger and younger every day, every time I walk in there. But that's what they make. We do have school teachers that actually qualify, and they would qualify to live here, full-time school teachers. There's probably about 25% to 30% of the Provo City employees would qualify to live here. So with the county employees. The hospital, we also have people from the hospital. I mean, these are great people. They're good people. They're just trying, and oftentimes they have larger families. They're just trying to get to that level of middle class. We're trying to get there.
Your board?
My board.
May I say a word about that, please? We have with us accompanying Ms. Weil today is Judy Kelch, who's the chair of the board. Welcome to you, and if you wish to have Ms. Kelch make comments, please invite her to.
Thank you. I appreciate that. Yeah, Mrs. Couch is the president of our board, and I'll invite her up. I have 3 board members here. George Stewart is also on our board. Dave Connect is on our board. Sherry Hall Everett is on our board. Celeste Kennard. I'm sure you all know Celeste. Dave Gardner, who is actually planning this project. Now, he was going to be here, and I need to tell you this now, and I'd rather do this now than in city council meeting, but he's had a family emergency. His father is not well, and has graciously asked you to be kind enough to allow him to be with his parents at this point. So, but he's on my board. We have Lou Goodwin on our board. He is the president and CEO of Green Dot Bank, who is the owner of Bonneville Bank. We have Bill Swadley from Bank of America Corp. And we have Randy Christiansen from the Joaquin Neighborhood Attorney. Honestly, I believe we kind of have a really amazing board. They are the top notch, in my opinion. They're it. They're the cream of the crop. So, have I forgotten anyone, Dave? Who? Kurt Pearson. Yes, former neighborhood chair in the Joaquin neighborhood. He has since, but is still a businessman in Provo because his office is in the Riverwoods development. Judy?
I know I walk like an old lady, but I'm having my knee replaced in about 3 weeks, and then it will be good. So time catches up with you. Anyway, I'm the board president, and it's been my pleasure this last year to serve as a board president. And we'll find out if they want me to stay another year Thursday or not, so we'll see, and it's okay either way. It's been a pleasure. But in the late spring, maybe early summer, I went into Charlene's office and I said, let's do this project. I said, either we'll make it or we won't. And if we don't try, we'll never know whether we can. And since I'm supposed to be your boss, I guess she decided to go ahead with it. But we don't do that. We work together. But I think this project, well, I know that this project will be good for Provo City because I have never done anything in the name of Provo City that I didn't believe was the best it could be. I would like to tell you a success story. As you probably know, I live in Dixon neighborhood, and Dixon neighborhood is now unqualified for CDBG money because of what NeighborWorks has been able to do there. So that is a success. So these things we do have, the end product is good, and it's good for us. And too bad we can't do any more down there. But there are other neighborhoods who need it, and we need to go on to other neighborhoods. And Charlene is wonderful in her management, and she will see that these units are taken care of, and that the neighbors around will enjoy these people, and they will add to their community in many, many different ways. A lot of people who graduate from BYU have moved into these affordable units and into our neighborhoods because when they first graduate from college, they don't have any money and they qualify. But soon they are making enough money that they either live in a place that they can call home and stay there, or they find a place that they can move on to. And that's a good thing for us because these are intelligent people who add to our community, and we're happy to have them here. Do you think of anything else I have to say? Does anybody have any questions? Yes, Dave.
Talk about what happens when they earn more money and how long they can stay. The fact that they can earn more money as a family, but they don't have to leave.
What Dave is alluding to is that a family may qualify the day that they move in, but they may get raises, and they may ultimately improve their living, their salary and income, and they do not have to move. And they will remain qualified until they reach 140% of the income level that they started at, which is pretty significant. Somebody could actually go clear to $24 an hour, which is out of poverty, and still stay. Now, they never have to move. It's just now they become a market rate unit, and the next available unit becomes an affordable one. So we will never, ever, ever have to kick somebody out based on their income.
Thanks for everything you're doing.
Mr. Leonard. Mr. Leonard.
Do you have a question about the homes that are on the north side there? We haven't had a neighborhood meeting. If they've been talked to and had the opportunity to give input to what they thought should happen on your properties there, have they been talked to?
They have not at this point. That's why I've talked to Catherine, and she put us on the agenda for tomorrow night.
Catherine Allen.
Catherine Allen, the neighborhood chair.
And so they'll have the opportunity at a meeting tomorrow. Okay.
Yes, I called Catherine. She says, Charlene, I just can't get everybody together and get you there any quicker than the 6th. And so we are on the agenda for the 6th, and we're ready to go. We still know quite a few people down there. So.
What we're being asked right now is to put it on surplus, and we apparently, I understand we've received appraisals on this property.
We'll ask Mr. Pepperoni to respond to those questions.
Yes, an appraisal was completed last week.
And feel comfortable with the market, with the appraised value? And
Yes.
I don't know if we've officially received any firm offers yet from NeighborWorks.
Yeah, they have submitted a written offer.
A written offer, and you're comfortable, and how close are we?
Well, between the appraisal and the offers, there's an $85,000 difference.
Okay, so that we have some negotiation, it sounds like, that we need to.
Yes.
Or some discussions anyway.
Yes, sir.
Thank you, Bill. Other questions or comments? This is properly a matter for the redevelopment agency, and that's the context in which it will be considered later today in our council meeting.
And Mr. West, just a clarification on your previous comment. The resolution tonight by the RDA is not to put on surplus property. That's a regulation that applies to city-owned property. The resolution tonight is to authorize an RDA chief executive or the mayor to enter into exclusive negotiations for an agreement related to potential purchase of real property generally located. So you're essentially authorizing the mayor to sell property.
Okay. And let me just ask you one question. I guess 10 years ago when you purchased that property, it was some of those funds for that purchase were through CDBG funding, and that's why we are obligated to the affordable housing. Is that correct?
It wasn't CDBG, it was other funding, but yes, that is correct. That's why we're obligated to affordable housing.
HUD funding.
HUD funding.
It's HUD funding.
Okay.
It sounds, from what Ms. Wild has described, it sounds as if it's probably home.
Okay.
What is unusual about the matter is that we're hearing about it now in this work session, and will be asked to vote on the motion to authorize the mayor in our subsequent council meeting. We have scrupulously attempted to avoid that situation as a council, so as to have at least a 2-week window between first considering and coming to a vote on the matter. If any fault should be taken, I am quite willing to take it and to view this as the chair of the municipal council as a kind of single exception, one time, based on the mitigating factors that Ms. Wild described for us, but also on the strength of the reputation of the organization.
If it's any comfort too, it has been a matter on our RDA agenda at least twice for 2 separate meetings. So we haven't had a chance to look at it.
Thank you for mentioning that.
Mr. Chair, if I might, one additional thing, I'm not sure the resolution is in the materials, but I think my recollection is that the resolution merely authorizes the mayor to negotiate a proposed agreement, which would actually have to come back to the RDA for approval before it's signed. So this isn't your only bite at the apple as far as considering whether to approve this sale.
Thank you for that clarification. This is not a motion necessary. Thank you very much, Bill. Ms. Kelch.
Charlene needs to say something.
So is this basically what I'm understanding is that based on what he's indicating that now we're going to negotiations and then have to come back in 2 weeks or maybe a month before that's the site control can be.
We can't get the funding unless we'll just have to develop our own.
You have a 15 August deadline, is that right?
That's correct.
I know, we know it's in imposition, we're sorry, but we have to try.
Thank you.
The resolution isn't in the material, so I'm going to have to pull it up and look at it exactly. I think the way it's currently drafted, it's just an authorization to enter into negotiations, not an authorization to actually execute the agreement.
So what that might require at the outside is a specially convened meeting of the RDA board.
We'll also look into whether we can amend the resolution tonight if you'd like to advance it.
Right. Good.
Thank you.
Are there other items? Mr. Jones, shall we adjourn here and then open the RDA board meeting?
So both matters.
Sorry about the second one.
Pardon? It's a good question. Will be the second other item on the executive sessions, RDA, or I think we perceive it as being RDA.
Okay. Certainly has the potential to be RDA.
So I think if we adjourn as the council and reconvene as the RDA, for purposes of the recording, well, you're going to set up a recording down there. Probably the easiest thing to do is just to reconvene as the RDA, make a motion to close the session here in this room, and then reconvene down the hall after that motion's been made, and just take the roll call and start the meeting.
So just to adjourn here, a motion to adjourn the work session.
So there's two motions, one to adjourn, well, we're not actually adjourning the work session, to adjourn as municipal council and reconvene as the RDA, and then a second motion to close the remaining portion of the meeting.
I'll make a motion that we adjourn as the city council and reconvene as RDA.
And?
Let's vote on
that.
that.
One at a time?
Yeah.
You sure we can't do two at once? A second on that motion. Thank you, Ms. Santiago. All in favor of the motion? Motion passes unanimously.
And so then, as is our wont with these closed meetings, I generally just make a comment before the motion that both of the matters that are to be discussed in the closed session deal with the sale or exchange of real property, which is one of the covered reasons under the statute for a closed meeting. That would be justified in these circumstances.
I'll move to close the meeting.
Thank you. Second, Mr. Van Buren. Thank you. All in favor? Motion passes unanimously. Thank you.